Well, good evening, everybody. It is Wednesday night, and it is time to talk all things Social Security. So today, as I've done in the past, I've guests. Today, I've got my good friend Stephanie Joy, attorney, and I'm going to bring her on right now. There she is. Stephanie, how are you doing tonight?
Doing great. Doing
Very
great.
good. Okay, and so we're going to do like we always do. We're going to answer questions. Um, Respond to comments, talk everything about Social Security disability. So let's just start with some of the comments I see here. I see Christina, who's a regular. Good morning. I think that was done a good bit of while ago. So good morning. I hope Christina, I hope you're here. But good morning or good afternoon to you. And we've got a question from John Calamus. He said he filed for SSDI in February of 2023. He retired at 62, decided to go back to work part-time. Let me just put this on the screen. He was under SGA for March 2023. Since that time, 9 months over SGA trial work period, if approved. So generally speaking, I'm not sure if I fully understand all this stuff, which are asking, but if the question is, can a judge find trial work period before you are adjudicated disabled by a judge? Yes, because the onset date would be the start date of when you became disabled, and you have 9 months of trial work period. Now, judges don't always go that route. Sometimes they do, sometimes they don't. Sometimes the judge might say that looks like substantial gainful activity. So it just kind of depends on the judge. Steph, do you have different experience?
No, yeah, I totally agree. I see he's saying under SGA for March 2023, but then have
9 months over SGA. Yeah. I mean, understand there's also something going on here. SGA is one number you have to be worried about, $1,550 a month, 2024. Trial work period is 1,110. So I think your argument might be better if you were over trial work period numbers, but under SGA. When you get over SGA, that starts looking like work. So if you're over SGA for 9 months, I think it's going to be hard to argue that you were disabled before then. But if you were between the 1110 trial work period and 1550 SGA, that's a stronger argument. That's my take. So I wouldn't assume you're going to get trial work period for a time if you were over SGA for 9 months. That's just
yeah, I don't even think they can do that.
yeah.
But John, you should, if you fit, you said you went back to work. Let's assume that you W-2 job, then you're not going to have, work-related expenses you could deduct down to get your net low. But do you have any impairment-related work expenses? IRWs, bring down your SGA. We've done that many times.
Yes, Steph, your audio is cutting out a little bit. I don't know if you have you get closer to a microphone, but you're cutting out a little bit.
Oh, no. Yeah, no.
Okay. Anyway, I think what she was basically saying was that if you have work-related expenses that allow you to work, that might be a basis to argue that you were under SGA. I mean, again, I think big picture is if you applied in 2023, and again, I don't know what your onset date, you filed in February of 23, let's assume your onset date was February of 23, and there was 9 months, especially consecutive months where you were over SGA, I think it's going to be hard to use that February 2023 onset date. It's probably going to be after the 9 months, because again, judges are, I can speak mostly about what judges are going to do. They're going to be reluctant to find somebody disabled when there's a big block of time, 8 or 9 months after onset that they work. So they're probably going to change the onset date, would be my take on it. Okay. SA says, is it possible for an age 60 woman with a current 27-year work history and severe depression, anxiety that meets the listing to stop working and qualify for SSDI? And I think what she's getting at is, and I get this question a lot, if you are working and you stop working, there's probably a limited amount of money you have to survive. So the question is, if you quit working, you've got 27-year work history, severe depression, and you think you meet a listing, if you stop working, is there good odds that you're going to get approved pretty quickly? I wish I could say that there was. I mean, and I had a question about this today. I had a person with a very, very significant medical problem, but he and his wife wrote me that he needs to work because he's got to have insurance. The problem is you can't assume that Social Security is going to approve you when you stop working. Maybe they will, and in the best case, you're looking 6 to 10 months. Maybe they won't, and you're looking at 18 to 30 months. So I would never tell somebody to stop working with the assumption they're going to get approved within 3, 4, 6, even 10 months. You agree?
I do. I
Yeah.
do. And never forget, at 60, and, we're all kind of there. Don't you have any physical limitations? I mean, remember, you only want to just prove you can't do your old job amongst other things, but you've got some rules that can help you. So if you have some physical limitations, body parts that don't work like they did when you were 20, and you can't do your job, maybe because of those mental things, if you have a higher skilled job or whatever, you have to kind of work a bunch of angles, so to speak, but reality angles, I think.
Yeah, yeah. So I'm telling you again, Steph, you're breaking up a little bit there, but her point was, and I'll just try to just get at the high points, is that if 60 years old, there's decent chance you may have some physical limitations too, that would be in addition to the mental health limitations, will make your case stronger and possibly make you eligible for the grid rules, because at age 60 you grid out at light work. And more than that, if you're limited to light work at age 60, Social Security would have to prove that you would have to make basically a minimal vocational adjustment to another job. So it's a lot easier to win after age 60. Not guaranteed. And that's the thing. People sometimes email me, I think I have a slam dunk case. There ain't no such thing as a slam dunk case in Social Security. They'll turn down, I just got a denial in a case with a judge that I wasn't real happy with the way he conducted himself, but neither here nor there. I had a lady who was, I think, in her 61 or 62 with like 3 ligaments torn in her foot. I mean, and so, I'm arguing that she's limited to at least probably less than light work. He found her capable of doing medium work. Absurd. Absurd. But, we'll appeal that. But, how is somebody with 3 torn ligaments in their foot, swollen, and never had any surgeries on it, but has, twisted it once, then twisted it again, and just, hobbles around with a cane, she can do medium work, lifting 20 pounds frequently, 50 pounds on occasion. I mean, but some judges will do that. So you just never know what you're going to get with Social Security. So the answer to SA would be, yes, is it possible that you would win? I think with mental health cases, that's even more difficult because mental health cases, there's no way to image them. You cannot, take an MRI of a depression or anxiety. So you're reliant on what the doctor says or the doctor's reports and how sympathetic a Social Security adjudicator might be. So that is the issue there. Jim says, I have no faith in the system. Okay, I don't blame you in that regard. I have a hearing coming up. I think I checked most of the boxes. I've had 2 CE exams that back up my doctor's claim. I think we have some more from Jim here. Why am I so worried? This all seems to be an end all with the hearing. Again, I would tell you that there's no guarantees. I think I would look at the approval rate for the judge. That'll give you a better idea. You could just type in Social Security Disability Judge approval rates, and you can find them many places. I wouldn't rely on just CE exams. I think that's consultative evaluation. You really need your own medical exam. I mean, have you ever won a case, Steph, on just CE exams?
Never.
Yeah.
No way.
Yeah, I think you got to have your own. So CE exams can help, but by no means are they, can you assume that's going to do it all? And Jim goes further on to say that he's diabetic, neuropathy, chronic kidney disease, history of myocardial infarction, heart failure, a lot of different things. And these are significant problems. And again, hopefully you've got ongoing treatment records from your own doctors, a cardiologist, maybe an endocrinologist, that talk about the functional limitations that arise from these things. But, as we've said many times, you don't win based on a diagnosis. You win based on the functional limitations that arise from a diagnosis. But I mean, these are pretty significant problems. I mean, I would think.
Yeah.
Okay.
Am I still
Okay.
choppy?
I'm sorry.
Am I still choppy?
Still a little bit choppy. Yeah. I don't know if there's anything I can do on it on my end. Let me
Yeah, I
just
don't know.
see.
I don't see anything on my end, but
Yeah. Let me see if I can edit the mics. Let's see. I'm going to turn off. No, we don't want to turn effect on cancellation.
Ooh,
I'm going to turn up the volume a little bit for you. I can do it from this end. We'll see if that works. All right. Angie said her question disappeared, but then it appears here. Okay. EDPNA, which I'm guessing, I think is a California. Is that not California?
I think that's
Or is that something else?
a lot of non-attorney reps. They're formally trained and they get
Okay.
their, yeah.
Okay. Filing for disability due to major depression, CPTSD problems. I'm not sure maybe just PTSD with concentration, persistence, and pace in 5 years. Only SE at a very self-employed at a very low scale, averaging 10K a year experience. Okay. So Angie's the EDPNA. Okay, now I understand. I'm sorry. Okay, so she's filing for disability, concentration, past 5 years, self-employed, low scale. So obviously, if you're earning $10,000 a year, Angie, your client's earning $10,000 a year, the monthly benefit's not going to be very high. Will the experience hurt her case? I'm not sure if I understand what you're asking.
I think she's asking if the fact that she's working the last 5 years that hurt her case. I think, is she still working it? It's under SGA.
Yeah.
10K.
Okay. So
I don't know that it would hurt.
and if that's actually a very good point. Have you found that, certainly the last 5 or 6 years, people that are working part-time, that used to be a real problem in my view, but I don't see it as much of a problem anymore. Do you?
No, I don't.
Yeah.
I mean, I always say to like my people, if you're gonna work, and I totally get it, I try to help them every way I can to learn how to do it safely. If you don't do things with your disability, first of all, don't do things that you say you can't do. Keep your hours down because that's what you can't do. And I don't, I don't find it to be a problem at all, really. I don't think a judge is gonna a person who's disabled. Well, you're working $5,000, $10,000 a year. I'm gonna be down. I don't really see that.
Yeah, I think, and again, I know, I don't know.
Every place can be different too.
Yeah, every place can be different. I mean, I think that, working ongoing part-time or under SGA is a, I don't see it as a big problem like it used to be. I used to tell people Social Security sees things in black and white. Either you're disabled or you're not. And now I think that because of the long delays and because of the reality that you have to be able to survive while you're waiting, people are going to be working part-time. The issue in my view is, you look at your earnings, and if SGA is 1550, which is what, 18,000 a year, it's not a lot of money. But if you're working part-time and you're right at the SGA amount, could a judge say, well, you're earning 1545 every month, that looks like you're intentionally suppressing your income. That could be the case. I mean, I usually tell people if you're going to work part-time, try to keep it in the $1,300-$1,400 a month, which is not a lot. Or if you have, as Stephanie pointed out, if you have disability-related expenses that would reduce your gross earnings, money you have to spend for, let's say a bigger monitor, or you have to have other expenses that allow you to work, a different type of chair, something like that, then that could come off the top. But, I think that working, part-time, averaging $10,000 a year, I don't see that as a big issue. Honestly, the bigger problem in my view is any case where you're alleging disability based on depression and PTSD. Those are hard cases. And I don't know what, Steph, what your experience has been, but I typically look for, indicia of severity. I mean, inpatient hospitalizations, multiple efforts by a doctor to change the drugs to get things to work, suicide attempts. I mean, it's hard to win these cases because, it's probably the number one reason people file disability is depression or mental health cases. And, you got to be way above and beyond kind of mild to moderate. Have you found that?
I do, and I think so much also, it depends on the vocational profile. I mean, we know that's so, like, if this person is an EDPA herself, that's a high skilled job. And so the mental, it doesn't have to be hospitalization, so you can't keep that job, maybe the concentration and all this stuff. But depending on your vocational profile and whether you have physical problems, would they be pushing that you could do an unskilled, low stress, minimum wage job, bagging groceries?
Yeah.
So much depends. We can't really, obviously.
Yeah, and it also depends on how old you are. I mean, I think that, if you are, 43 years old, it's going to be a lot more difficult than if you're 53.
So the vocational profile.
Yeah.
And I would say though, 10K a year, you're not really flirting with SGA at that rate anymore, right?
Right. SGA, that's
That's
way
like
below
$900,
Yeah.
So that part is not so bad. It'll really be your evidence shows.
And I think, as an EDP, and I mean, I'm guessing that there's going to be some skills that would transfer there. So, that's obviously a skilled occupation. So that would make it more difficult. I mean, again, we don't have all the information here. I think the work part is not as much of an issue in our view. I think the other question is how severe is the problem, and what does the evidence show? What does the evidence show?
And I think CPTSD is chronic PTSD.
Yeah.
Not just
Say again.
something more sure. Chronic
PTSD. Okay. Yeah. And PTSD is one of these things where, again, my experience has been, if it's something that happened to you, you were in combat. So I had a case one time where somebody was sitting at a desk and somebody, an ex-spouse or something comes in and blows away the person right next to them. That is one level of PTSD. But if it's something that's happened to somebody else, kind of in a more remote way, that can be a little more difficult to prove. I find that it usually is stronger when something has happened directly to you, in your personal space, as it were. Because, PTSD, you could theoretically get PTSD from, just from being in a bad marriage, let's say, even if there was no abuse, but, or no physical abuse, and there's more emotional abuse. Those are harder cases because, again, everybody's different, and some people will, experience PTSD. But my point is that I think many judges, at least in my experience, are going to look at the trauma. What's the underlying trauma? And is it reasonable that the trauma this person suffered is going to cause PTSD? Being in a combat operation for a year where, there are roadside bombs and people are firing at you, that's one thing. Being in a working, and I remember I had somebody who was in a kind of a hostile work environment for 3 months. Not to say they're to have it, but that's a much more difficult road to go down, at least in my view.
I don't disagree.
Okay. All right. Teresa says, my case is with DDS for medical review. DDS is Disability Determination Services, or we call it the state agency. This is where the state has, or the Social Security has contracted with your state of residence, the department there in your state to evaluate your claim. So realize, even though Social Security is federal, DDS, DAS, there's a bunch of different names for them depending on the state. In Georgia, it's DAS, but other places it's DDS. That they're looking at, they're doing a medical review. The attorney I spoke with, completed my intake paperwork with, said they're going to submit the records I sent to their office. Will it take 230 days to review and make a decision? I'm confused in the timeline. Does the timeline start from date of initial intake, from phone application date? Well, first of all, the timeline is a rough estimate. I mean, I have cases right now. There's a DDS or DAS office in Georgia that literally they haven't assigned an adjudicator. It's been 10 months. They have not even assigned an adjudicator. I've got another one in another state where it's been 13 or 14 months. No adjudicator has been even assigned. It could take, and it's ridiculous and it's just absurd. It could take well over a year before anybody even looks at it. So there's no, the 230 days, that's just a number. They're going to get around to it when they get around to it. And what I tell people is if you have been waiting for 5 or 6 months and you're not hearing much of anything, that's when it's time to make a congressional call to, or email to your congressperson, U.S. senator, and say, let's do a congressional inquiry here, because it could take forever. It can really take, a year and a half at the initial application, then another year at recon, and lo and behold, we get to a hearing. It's been 3 years. I've had cases, I don't know if you have, that's been 3 years. So it just depends. So the DDS.
Yeah, and you don't know if you're just like, well, you're in line with other people and it's FIFO, first in, first out. You could they could literally have lost the case. You just don't know. That's the problem with it, because there's no, for people that don't have representation in particular, but at least see the ERE, that an existing, we know they're an indicator. Go in and see, but they can't see.
Yeah. And I know you broke out or cut it out a little bit, but what Stephanie's saying is that your attorney can look at something called the ERE, which is Electronic Records Express. We can look at the docket, essentially, or part of the docket, not all of it, but we can at least see that there's action happening. So I may log into my client's file and I'm looking at sections E and F, which is what we're allowed to look at the initial stage. And by hearing, we can look at A, B, C, A, B, D, E, and F.
C.
We don't see C. I don't know what's in C that's so mysterious.
I don't know. It's got to be dirty or something.
There's some sort of secret code in there. I don't know what the hell. But we can look at E and F, and we can say, okay, there has been some activity. They're requesting medical records. There's letters, but I've looked at ERE dockets before, and literally there's nothing going on. It goes 6 months. There's nothing, a big fat zero. So in those situations, I would tell my client to reach out to their congressperson, because it's that's just way too long. But it does happen. So unfortunately, Teresa, being at DDS, just means that the process is starting. Ideally, you get a decision 6 to 10 months, but it could be longer. But I think if it goes more than 6 or 7 months, you're not hearing anything. You elected these Congress people, make them earn their pay.
Yep.
That's my take. Okay. All right. We have a question from Gretchen. I just received my decision letter for my hearing. I'm assuming it was favorable. How long does it usually take to get the award letter and release of funds? So it looks like Gretchen was approved. Congratulations. The two-part answer to that is normally you should get your funds in about a month or so, maybe less than that. If there's an SSI component to it, however, it could take longer, because SSI has to do this income and resource thing, and that can take, weeks and weeks and weeks. So it just depends. It also depends on, the file could get stuck on somebody's desk. I've seen that happen before. So ideally, you get your money within, let's say, 3 to 4 weeks after your favorable decision. But, we're talking Social Security, so who knows? What's your experience been?
Same, exactly what you say. And workers' comp can also slow things up too. If you have a workers' comp, they're going to want to find out if any months overlap and all that business.
Yeah. And the reason for that, by the way, when they do their decision, workers' comp is an issue because it offsets Social Security. If you're getting workers' comp ongoing benefits, it's going to offset your Social Security. And if you have a settlement, they're going to want to look at the settlement documents to make sure that that your settlement basically has some language in there that says that your lump sum is reflective of your expected lifespan, so it doesn't offset your Social Security dollar for dollar. So that's why they're going to ask for that. They also are going to do what they call a non-medical review, where they're going to look to see is there any kind of work activity going on after you were, after you applied and after you were approved, and they need to go through that. So, there's a few checks and balances they've got to go through, but the real delays are the cases where there's SSI or there's workers' compensation. I had a case where there was a long delay because my client had a green card and they wanted to see original documentation. So there could be any number of reasons that's a problem. And I've had a couple of cases where it went stuck on somebody's desk and that person retired or got fired and it just sat there for week after week. And so, we're calling what's going on. And finally you get a live person with a clue who could unstick it. But it could be any number of reasons. But hopefully, these are all, the exceptions. Most of the time, I'd say 80% of the time within 3 to 4 weeks after your favorable decision, you should start seeing some cash flow. Okay. Robert says, if I will be 60 in 3 months, should we be using the 203 grid rules? We're stuck using the 202 grid rules because you're 59. I'm not sure if I understand when you're saying 203. Let me pull up the grid and see if I can see. I mean, the point is that what a judge would do, big picture with when he says 203, I'm not sure if he's talking about 202.03 or I don't know exactly what he means by 203. The grid rules are, the sedentary grids are 201s, the 202s, the light grids. But the point is that your case at 60, you kind of change classification, although the grids only talk about 55 plus. Where 60 comes into play would be what they call the POMS, POMS classification of transferability of skills. But let's just say, for example, that you are 54 and turned 55. What a judge could do would be at 54, they'd use the grids applicable to people at 54 through 54 to their 55th birthday. Then part two is after that they could look at the different grids. So the judge might amend the onset date to reflect your change in age to your 55th birthday, or the judge might say, you meet the grids at 54, therefore you by definition meet them at 55. But they're not going to. It's not going to be once you hit 55, it grandfathers you in at 55, going back to when you were 53. 50 between whatever age till age 50, your 55th birthday is one set of grids. After 55, a second set of grids. At age 60, the POMS regulation about transferability of skills kicks in, and so that changes. And again, you may sometimes it's less likely between 59 and 60 to see a problem. But when you're changing age categories, judges sometimes will then change the onset date, which usually does not work in your favor. Is that how you read this question? I'm not sure.
Yeah, I think so. I don't even look at the numbers. I look at the, whether the grid applies is going to depend on the facts of the case too. But I mean, the grid always that. But which one will apply to you?
Yeah,
up in the air. But yeah. So if he might be asking also. I think you might have touched on that, Jonathan. If I'm very close to the new grid age, will they pop me in? They can do that, right? But a few months before the birthday, they can say close enough, which is kind of nice. If they do it, they don't have to do it.
Yeah, and what you say, there's something called the grid framework. And so the point is that let's say that you're 54 years and 8 months or 9 months. A judge could say, well, the framework of the grids, even though you're not quite 55, we're going to apply the 55 grid because you're really close to it. I've had that happen a few times. It doesn't happen a lot, but some judges will do that just because, the reality is, what is the practical difference between somebody who's age, 54 years and 9 months and 55? There's really no difference. So, if the grids apply, then that would be what way they could do it. Judges can get creative. It's kind of interesting. When they want to approve you, they can get creative. Again, I think I mentioned this in a previous live stream. I had a judge one time basically decide that the person had gone back to work, and she's like, well, I'm going to treat that as a trial work period, and then I'm going to treat some of it as an unsuccessful work attempt, and basically gave my client an extra 15 months of benefits. Because she recognized that he only went back to work because he had no choice, because he had to feed his family. He was a single parent, had to feed his kids, and that he was getting all kind of special considerations. And she felt bad for him, and so she went out of her way to help him. So some judges will do that. Other judges are like, well, we're not going to. I don't care. And like the judge I had with the torn ligaments. I mean, just he didn't like the lady, and so sorry, not gonna help you. Okay. Luca, weren't you in The Godfather? I think we got to be nice to Luca Brasi. I think that was a Godfather person. But anyway, people asking questions, not even live yet. Yes, they do. That's fine. Okay. Hello, Sebastian. Rodney is here almost. Well, you missed last week, Rodney, but you are here this week, so I appreciate that. Christina is here. Sebastian says, hello, Stephanie. And looks like you've got a fan club here. Okay, and we got Jen, who's my paralegals. Hello from Lincoln, Nebraska. Hello, Jen. And you said you promised you were going to be nice, so I'm glad. Hope you will. Okay. Some of these questions we've asked were people that commented before we even started. Sebastian's in York, Nebraska. I assume York is a major metropolis someplace in Nebraska. I don't know, but all right. Hi, everyone. Okay. Yes, Leah, you are one of my clients. Hello. I recently signed up to get disability for lymphedema. How long on average it takes, everything filed. Once we have, I can speak for our practice. Once we have all the paperwork, normally I get it filed within a week. What I do is I get the questionnaire. And Stephanie, you tell me how you do it. I get the questionnaire. I have somebody draft up the application. I review it. I'll make comments. If, let's say, it looks like it's a grid case, I'll make an argument there. Just review it all to make sure that it's all accurate. I've got a really good paralegal who prepares the drafts, but usually it's going to take anywhere from 3 to 7 days, depending on when we have everything back. What's your typical time frame when somebody retains you to file an application? How quickly do you normally get to it?
We do it kind of in a, I don't know if it's a different way. It might be. I gather a lot of the information from them on through the portal we have. Well, you and I use the same portal, right?
Yeah.
There's different packets, and they go out staggered. So there's like the medical info pack. If we're gonna, because we draft the application. The stuff that would be for the first part of the application, I call that like the T2 stuff. That's another pack, so that they're not it's just
overwhelmed.
Most need, not overwhelmed. So when they so like the sign up packet, which is what the 1696, the 1693, and I'm sorry guys, I'm going. I don't even know what to do. Yeah, it sounds like it's pretty bad. No.
Yeah.
I don't know. How to,
yeah. Do you have a micro? I'm just curious. Are you wearing like a lav mic, or do you have like a?
No, it's my laptop.
Laptop. Okay.
Any clue, guys?
Yeah, I don't know. That's interesting.
I'm sorry. It's gonna be
okay. I'll try to repeat, the gist of what you said. Yeah.
And it's funny because I almost hear it go, but anyway, I just don't know how to fix it. Like I'm like I asked somebody, I'm like, is there any tech people out there that can help me? Yeah.
It may just be your connection. I don't know. I know that I use, just for whatever it's worth, I use I'm not using the microphone for my webcam. I'm using a separate microphone into my computer. So when we're offline, I'll show you what I use, so you can see if it makes sense. Yeah. Because sometimes those microphones from the webcams are not ideal.
Right.
By the way, if you is what we're getting off field. What brand of webcam do you have? Is it like a Logitech?
It's with my my Mac.
Okay, with your computer. Okay. All right. So we'll get you fixed up, but okay. But yeah, but I think what you're saying is that you kind of dole out the packet in bits and in parts so that people don't get overwhelmed. What I do, and Leah, this is when somebody retains me, we send them like a DocuSign or a HelloSign packet that they would fill out that would retain me. And then at that point, I send them an intake questionnaire that is through my case, which is our client management software, and it's basically online, web based, and so they can go into it and they can answer the questions, and it really tracks the intake form or the Social Security intake questionnaire, or I guess you call it the application. Really, it tracks it kind of actual question by question, but they can go in and come back out of it. So we find that tends to work. People will get that. I used to use a written questionnaire, but I don't really use that anymore. It's all kind of online, and people can kind of come back to it as they need to. And sometimes they need to come back because they need to get more information. It's interesting when you look at these applications, they're going to ask you, what was the name of your high school? They're going to ask you when you graduated. They're going to ask you all these, if you have had a previous marriage, the social security number of your prior spouse, and the date of your marriage, and the date of your divorce, and all this stuff. And it's just it can be very, very, some of the stuff is just, you may not have it right nearby.
Right.
So, it can
John,
be.
what do you think of me getting out? Garrett just suggested this. Try rebooting. I don't know, and then I'll just pop in and get your link.
That's fine. Yeah, go ahead and do that, and I'll see when you come back in, and then we'll try that, and then I'll just keep answering questions.
Sounds good.
Okay, very good. Okay, so let me. There you go. She just disappeared. Okay, so she's going to reboot. Okay, so Leah, I hope that answers the question, but normally it'll be filed. In fact, I'm not going to discuss your case, obviously, but I'll as soon as I've got everything, we'll go ahead and make sure it gets filed. Usually I'm pretty quick about it. I've got a paralegal who drafts everything up, and I get it, and she says it's ready for me. Then I go ahead and log in, and I make the changes and get it filed. So I will do that. And some people, by the way, want to see the application before I submit it. Others, doesn't matter. To me, it's more important to get the thing filed. We can always change things later. All right, Muley. And Muley's got a picture of looks like a moose there. So I'm not sure where Muley lives, but I'm guessing it's someplace in the Great Northwest. I'm a 100% permanent total vet, 70% PTSD, TBI, broken back, shoulder, joint replaced, nerve damage, bulging discs, sleep apnea, 54 years old, worked and paid in for 38 years. Okay, so right there, it tells me that you might meet the grid as age 50. If you're limited to sedentary work, you might very well meet the grid. And again, if we look at that, I'll show you the sedentary grid here. Let's go ahead and share that, present. And here we go. Okay, so here's the sedentary grid. So at age 54, if you are, and you've got, let's say, semi-skilled work, if you are a high school grad or more, 201.14, your high school grad or more does not provide for direct entry into skilled work and no transferable skills, you are disabled. So the grid very well might apply. Now people say, what about transferable skills? I've done some really significant things in my work background. I've got transferable skills. If you're in severe pain, if you can't get a good night's sleep, non-restorative sleep, that's a situation where, whatever transferable skills you might have might very well be eroded by these, what they call non-exertional limitations. So the first thing I would say would be, it might very well be that you meet one of the grids here, specifically grid 201.14. If you do not, there is the argument, a functional capacity argument, where you would argue that the combined effect of these problems would leave you unreliable in a competitive work environment. Realize that, PTSD is going to interfere with attention, concentration, focus. Maybe it would interfere with interacting with the public or coworkers. A TBI, traumatic brain injury, might very well interfere with your ability to focus and concentrate. Broken back, shoulder joint replaced, nerve damage in the neck is going to be painful. It might limit the use of the hands in terms of lifting and carrying. Bulging discs might limit you in terms of standing and walking and physical, which again, the grids are based on physical. A long work history benefits you because judges really appreciate people with a long work history. So I think that, I would look at this as a grid rule argument, but the alternative, I would argue functional capacity. But assuming that these medical problems all produce very specific work limitations, you've got evidence to that effect, then that would certainly be something that could be useful to you. Okay, let's see, Stephanie, you are back. So now I don't hear you at all. So now we have no sound whatsoever. So it's not breaking up, it's just silent. So let's see if there's anything. I don't have any mute on my end. I just unmuted you, so you are not muted. You are somehow being muted on your end. Let's continue on. How long does it get your first payment? I think we talked about that, and that would be, ideally 3 or 4 weeks, but it could be longer. All right, Teresa, this is a lot of echo from Stephanie. We knew that. Okay, so we're working on that. Let's see. Jose Ortiz says hello.
Can anybody hear me?
There you are. Okay, now we're back. And that sounds better too. All right,
Am
Jose
I echoing?
it doesn't sound like it's too bad of an echo now. Let's see how it goes. All right. Jose says, I've been receiving SSDI for nearly a year as of February 24. Oh, that's not a year, so that's only a few months, but I'm covered by TRICARE. How does Medicare work? Well, being enrolled in Medicare at 65 or earlier. You become eligible for Medicare 24 months after your first eligibility for Social Security disability payment. So if you started receiving benefits, or if your past due benefits began as of February of 2024, not the date you were found disabled, because there's a 5-month waiting period, but after the 5-month waiting period, the date of first payment, or that lump sum is applied to, 24 months after that, so this case would be March of 2026, you become eligible for Medicare. And as long as you've got TRICARE in the meantime, that allows you to go to the doctor. I've never understood why there's a two-year wait for Medicare when you have people that are disabled, they can't work, they have no insurance, they have very little money, but you tell them, you can't, we're not going to give you any insurance, and yet, then they say, well, you're not going to the doctor. Well, of course not, because I don't have any insurance. But that's the rules on that. Okay. All right, and Garrett is telling us, please. Okay, and I've got that scrolling across the bottom there. All right, so Yuli asks, this is the person who had the PTSD and the TBI and so forth. He filed in December of 23. How long for them to make a decision? I would say, again, 6 to 10 months on average. So, September, October is probably likely. What do you think, Steph? Sounds. Now you're silent again. Wait, now you're muted again. So, not sure where that's going on here. Okay. No, you're still. I'll let you know when you talk, but you're muted right
now. Am I now?
Now you're okay. I just heard you there.
I went into settings again.
Okay.
Yeah, I should just stay away from tech.
Yeah. Okay. All right. Garrett says hello. Ivy, hello. Ivy. Okay. DD. I'm still waiting on my initial decision through DDS. It's been 6 months. I started waiting on my carpal tunnel surgery report. Is that normal? Yeah. I mean, I think that, when you have a pending surgery, I've seen DDS adjudicators say, well, let's just wait and see what happens, because that can make a big difference. Because obviously prior to the surgery, and again, we're assuming you haven't been out for a year. Prior to the surgery, let's assume that you were having really difficult time using your hands. After the surgery, it was successful, that may mean that you're not out of work for at least a year. You don't have a disabling condition for a year. If the surgery does not go well, then, you may have that year. So, if you have a pending procedure, I've seen adjudicators say, yeah, we're going to go ahead and hold off on making a decision until after the surgery. Have you seen that?
Yep. I've seen them, like they called it a stay.
Yep.
Just to get a little bit something after, which I think is kind of nice, actually, because then they haven't lost that bite of the apple. Am I doing bad?
It sounds a little fuzzy, but you're not echoing as much as you were, if that makes any sense. All right. We're going to have to get you a microphone, but we'll work on that.
I know.
Crazy. All right. My case, And I'll send you what I got so you can sort of try that because it's pretty inexpensive.
Believe it or not, my son has, because he likes to game a little bit.
Okay.
Unfortunately, so maybe I'll ask you to show me something.
Yeah. I just think you probably relying on a webcam mic is probably not the ideal situation. All right, Ivy's case went to the circuit court. That's unusual. Normally that goes to the district court, but circuit court's a pretty serious appeal. Eugene says that you helped him win his case 3 years ago. So that's
Who me?
yes. He said Eugene Pagan says, "Hello, Joy." I guess.
Oh, Eugene.
Okay. Yeah.
Good to see you.
Okay. How long does it get approved in a circuit court review? Well, circuit court, again, I'm not sure if we're not using accurate terms. That's the level above the district court. So that's a whole nother level of appeal. That could be years. Now, maybe you mean that you went to the appeals council, then went to district court. That's going to be, 5, 6, 7 months. But realize when you're dealing with these circuit courts or even district courts, they kind of work on their own time frame. So, cases that go, and I've had several cases go to district court, then go back, by the time we're all said and done, 4 years, 5 years, it can take a while. We got terrible feedback on Steph's end. Okay, well, we'll just deal with that. Okay, Russell. Okay, you've got, I have really bad spinal damage throughout my spine. I have rods in my lower back and need them throughout the spine. I've had surgery on both shoulders, both knees, my hips. Do you think with that it would be faster? Probably. I mean, again, you still come back to, they're going to look at, obviously, a significant medical problem. Question one is, has this improved your condition? Are you now more functional in terms of work? Or do you still have significant problems? So again, all these procedures you've described don't make you disabled. It's just, it's a signal that it's something pretty serious. So the question is, how is your functioning now? That's really the question. How is your functioning now? And logically, with this amount of surgery, this amount of problems, I would think that you've got some scar tissue, you're pretty uncomfortable, but you got to have that in the medical record. Also depends on how old you are. If you are 35, it's going to be a more difficult case than if you are 56. You're 56 with all these things, and you testify that you can't stand for more than 10 minutes at a time, and you can't lift more than 10 pounds. You grit out. But if you're 35, you got to prove you can't do anything at all, and you got to have evidence to basically say that these problems have resulted in inability to function reliably in a workplace. But I would think that rods in the back, that's going to be a significant problem, and scar tissue does form. Eric says they don't want to hear 202.06 from me. They want to hear it from you. Thanks for taking my case. Okay, well, that again, this is again one of these situations where ideally, you could say to Social Security, look at grids 202.06. And, that's why I've got all these videos out there. Steph's got a whole video library too, that you want to be able to say, you could, some of the stuff you should be able to do yourself, but sometimes it's kind of hard to get through to them. And, you get an attorney that, does it in sort of their language. And that's kind of what we do. I mean, it's kind of like, people say, you pay a CPA to do your taxes. Why should your taxes be so difficult? You have to have a CPA do it. Well, because they sort of know the ins and outs. I mean, I think it's the same kind of thing. As attorneys, we kind of speak their language, and it's gotten so complicated with some of the. I always talk about. I think every week I talk about all the abbreviations. DLI, AOD. DLI is date less insured. AOD, alleged onset date. TWP, trial work period, SGA, substantial gainful activity. They sort of talk their own language. And so, what we try to do is really address what they want in their language. But I'm glad you hired me, but, I wish that Social Security would be a little more easy for people to navigate. We got some major echo going on. Garrett says, any suggestions, Roy? Okay.
Yeah, I'm hoping it's better now. That was a half hour ago.
Yeah, that's true. That's true.
Or maybe
it's a little bit better now.
I
Okay.
think Lewis said he thought it was not as bad.
Yeah, it's still, it's not ideal, but it's maybe a little bit better. All right, Bonnie says, I had a stroke. It affected my cognitive abilities. I have diabetes and blah, blah, blah. I don't see where the rest of it is. Oh, here we go. Let's see. And I have trouble communicating. Okay. So Bonnie has a stroke. Again, Bonnie, we don't know how old you are, but assuming that you're late 40s, early 50s, something like that, or no matter what age, if you have a stroke, it affects your cognitive abilities. That is going to almost certainly impact you in a work environment. So, you know, I normally would assume that somebody who's had a stroke, they're probably going to be limited to a simple entry level 1 or 2 step job. Now that still means, doesn't mean if you can do that, you're not disabled, but it eliminates a lot of jobs out there. Social Security uses, and we've talked about this, a resource called the Dictionary of Occupational Titles, or DOT. If you go to occupationalinfo.org, you can look at it. And this is a publication that was last updated, I think, was it 35, 40 years ago. I mean, it's just in the 1990s. It's way out of date, but they still use it. I don't know why they can't find something better, but they have it. So every job in the DOT is going to be classified as either sedentary, light, medium, or heavy based on the physical requirements, and it's going to be unskilled, semi-skilled, or skilled. So by definition, a sedentary or sit-down, unskilled job is going to be one of the easier jobs that exists. Just recently, Social Security basically told us that a certain number of these sedentary, unskilled jobs no longer apply because they don't exist anymore. But there are still some that do exist. So I think that at a minimum, or more, I shouldn't say that, but I think there's a good likelihood that in order to win, Bonnie, you're going to have to show that either A, you can't do anything, or that certainly you could not do one of these simple entry-level 1 or 2 step types of jobs, assuming your stroke did cause significant problems with attention, concentration, focus, emotional stability, all those kind of things. And the diabetes obviously is going to impact you in terms of, your blood sugar. If it's out of control, it's going to obviously impact you in terms of focus and concentration as well. And perhaps there could be some vision issues. There could be some neuropathy in your hands and your feet. So all those things add up. Steph, would you agree with my analysis there?
Yeah, I agree with all that. And focus on all those other peripheral limitations, like you said, the neuropathy and vision could be low. Maybe you can't do that small part assembly.
Right. Right.
So
Absolutely. Yeah, I think that, again, I think, what I like to tell my clients is we look at everything as attorneys through the lens of how does this affect you in a potential work environment. That's really the key point here. And I've said this a million times. You don't win because of a diagnosis. You don't win because you have a herniated disc. You don't win because you are diabetic. You win because your diabetes causes you not to be able to see for 3 or 4 hours in a day, or your diabetes causes you win because of your blood sugar gets so low that you have to lie down for 45 minutes twice a day. Your back, you don't win because of a herniated disc, but you win because you're limited to sitting for 10 to 15 minutes at a time, total of 2 hours in a day, and standing 10 or 15 minutes at a time, total of 2 hours in a day, 4 hours of constructive time during the day because of the back problem. What Social Security is going to look at is the nature of your problem, and is that consistent with the limitations you have. But you want to be very, very specific when you talk to Social Security about your limitations. Don't say, I can't sit very long. I can't hold very much. You got to be very specific. I can't sit for more than 10 or 15 minutes. I can't lift more than 5 pounds on a regular basis. And that's what wins cases. It's really about functioning. And when it comes to cognitive stuff, it's, memory, processing, staying on task, emotional stability, adapting to changes in the work site, interacting with coworkers and supervisors. Sometimes when you have a stroke, you have changes in those things that would make you less reliable. And I think this is really more about reliability and dependability.
the devil's in the details.
Absolutely. Absolutely. All right. Eric says, what apps do you use for hearing? Is it Zoom? No, it is Microsoft Teams, which is actually probably better in the sense that they send you a link and you don't have to have Teams installed on your computer. So it's Microsoft Teams if you choose a video hearing. One tip, though, I would tell you, I've had people use Microsoft Teams for a video hearing with their phone. And I think it's better to use a laptop because with a phone, you're trying to hold it and the phone's, moving around and you're jumping around the screen, and judges just don't like that. I think they much prefer that you're, have the phone placed on a stand or something where it's very still and you're just, you're talking. I would also tell you, my experience has been that if there's going to be technical problems, it's much more likely with video hearings than telephone hearings. I've had, situations where a judge couldn't get on, or we couldn't hear anybody, or, the video dropped out. Video hearings are great, if you want to see the judge, and there's some value to that. But, the odds of a technical problem, go up. Phone hearings is really much easier. Have you found the same thing? Do you do a lot of video hearings?
I largely do video, but it's always with the caveat that judge, if someone slides sideways,
Mm-hmm.
and sometimes it's the judge with their tech, we'll go phone. We're not putting this off if we don't have to.
Yep. That's actually what they use, interestingly enough, as I understand it, when they're doing a telephone hearing, they will use Microsoft Teams to record it. So I think it's the same software, but it's just one's got video, one does not. But yeah, if they're having trouble with the video, they'll just say, we're just going to make it a phone hearing. They'll ask you if you have a problem with that. Let's see. They are hard based on merit. The system is rigged. I don't know that I would say the system is rigged. I think that, you have some judges who have a much more hardline view as to what it takes to be disabled. They're not going to, if they deny you because the judge puts in there, this person wore purple, we're denying them. No, that's appealable. But yeah, there are some judges, if you look at the statistics, that approve 35%, 25%, 20%, 17%, and again, their notion of what it takes to be disabled is just different than everybody else's. On average, I think, what was it, like the last waterfall chart, I think it was like 48%. My personal opinion is that if a judge is more than like one or two standard deviations away from the average, meaning that, if the average is 48% and you got a judge at below 40%, that inherently means there's an issue there, because judges denying a much higher percentage of cases. And, what's the deal with that? And the same way, if a judge is approving, 85% of cases, then, they're going to be looking at that. In fact, a number of years ago, there was a hearing in Congress. I think it was South Carolina Representative Trey Gowdy, who's now not in the Congress anymore, but he was in the Congress. And he basically raked a couple of judges over the coals. I've got it in my YouTube channel, the video of it from C-SPAN. And there was one judge that I'd been in front of who, approved 99% of his cases. And Gowdy's like, how in the world can you say that 99% of the people you're approving or you're seeing are disabled? But I would ask the same question. How can you say to somebody that 80% of the people you're seeing are not disabled when everybody else says it's closer to 50%? But, the judges do have a lot of independence. You'd like to think that there's some sort of oversight on ones with a really low approval rate, but I don't know that there is. I just think it's just, sometimes the luck of the draw. And I don't know, I don't know if you see anything different, if you have judges that are just, off.
We've got them up and down, and I agree. It has to be more of their, they're judges. Judges come with their discretion, right? They come with their life experiences. I do hear a lot of people talk about, quotas and, unofficial things, and, I don't know. I see the differences. I know there are different discretions with judges. I like you said, Jonathan, I've never heard a judge getting reprimanded for too low of a rate.
Right.
But we know they've gotten reprimanded for too high a rate. So
there was one class action out in New York a number of years ago where I don't know maybe the Brooklyn hearing office, this is going back a number of years, where there was a class action where the approval rate in that office was just dramatically lower than any place else. And, there was a class action and a appeals court came in and made them go back and kind of review and redo a bunch of cases. But that's the only time I've heard of that. I remember I had one. I was talking to a colleague one time, and their point was a very interesting one, that a lot of the judges that are appearing before these cases, they've been lawyers, they've been in practice for a number of years. They have, and if they're working for the government, they have good insurance, and so in their mind, you have a herniated disc, you go into a good surgeon, the surgeon, does his thing or her thing, you go to, some sort of physical therapy afterwards, rehab, and you're okay in 3 or 4 months. But the reality is that a lot of people don't have access to that, and the quality of medical care can really vary. And you're in some rural area, and you've got one hospital that services half of a state, let's say, and the doctors there are just not very good, or the person can't afford the physical therapy afterwards, and so they're not going to get as good of a result. I mean, my wife, for example, does workers' comp, and just in Georgia. I mean, for Social Security, we're national, but for comp, it's just in Georgia. And she tells me, because I just got a message here. Never mind. But she says, like, the quality of medical care in rural Georgia is a whole lot different than it is in Atlanta or Columbus or Savannah. And it's just because they don't have as many doctors, and the doctors they don't get paid as much, so they don't attract the best talent. Not all of them, but you do see that sometimes. And even in a big city like Atlanta, there are some big practices here that bought up other doctors' practices, and they take in a bunch of different doctors. And some doctors are really, really good, and others are not quite as good. So it just depends. And an orthopedist, for example, if an orthopedist specializes in shoulders, you don't necessarily want that person operating on your knees, but you may not have a choice. So I think that I think sometimes judges don't realize that the quality of medical care that claimants get is not going to always be gold level. And sometimes when the results aren't as good, it's harder for them to understand that. So that's been my take. I remember, just one aside, I remember I had a judge years ago in Atlanta who was notorious for being a really hard judge. I mean, he approved very, very low percentage. They didn't have this is, before there was any statistics out there, but this judge approved very low percentage of cases. I had this case with him, and my client's problem was swelling. Basically, this person had some vascular problems, and his legs were swollen. And the judge basically approves it on the record about 10 minutes into the hearing. And I about fell off my chair. And my guess is that this judge had someone in his family, or maybe a spouse or something, that had, some sort of vascular problem and swelling and so forth. And he knew how unpleasant that was. And yet, so he approved it. So that could be the situation. So you never know. So I don't think the system is rigged, but I think it's certainly could probably be a little better in terms of the way they do it. So that's just my take. Okay. Well, she's not using a cell phone, Roy.
Yeah, I think that's old.
Yeah. Okay. Okay.
I try to answer a couple of those, like,
yeah.
So what do I do?
Yeah. Yeah. Okay. Blah, 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 blah. All right. MS since 2003. Retired military. Walking issues, fatigue, hand-arm weakness, bladder, cognitive issues remain. Disability before DLI. Can I file an onset date before 2008? Yes, you can file an onset date before the DLI, even if it's 3 or 4 years back. Now, when you're talking about a remote onset date, it is going to be a little bit more difficult. So, because you've got to prove that your disability began, really before, before the date last insured. And if that's 5 years ago, that can be a bit of a problem. So, it is, it's going to be a bit of a challenge, but it's doable. Have you ever done that? Have you had situations like that?
Yeah. And it's hard. I've got a couple right now. Remote DLIs. I have under 50 lately. When the DLI, I had a hearing on one actually. Person still has an open DLI, but he will not be 50 before it's over. And I say that only because I'm always looking at plan B if things slide sideways, because you just want to take care of the person in the end, one way or the other. You have to have a really crazy difficult case. But yeah, those remote VLIs are
difficult.
and often it's because people don't know. Like I didn't know before I started practicing this area years ago. DLIs and Social Security disability is like term insurance.
Yeah.
And I think many people could have prevented it had they known. Just a little bit of work, for 4 more years, very part-time work.
Yep.
And they could
Yeah.
extend that out.
And just so, again, the date last insured, this does get a little confusing, but date last insured is when you're no longer, how long are you insured for disability purposes? So when you stop working, you've got to basically, and it changes if you're younger, but for the most part, if you have credits, you've got to have earnings credits, and that's going to be about $7,500 a year to get all 4 credits. You've got to have 20 credits in the last 40 quarters. 5 out of 10 years. So if you stopped working in 2019, your date last insured will likely be in 2024. It follows you for about 5 years. But if you haven't worked in 10 years, you're not going to be insured, after, let's say you stopped working in 2010, your date last insured is going to be 2015, probably, something like that. And so you got to prove you became disabled in 2015. That is a major uphill battle because we're now in 2024, and to prove that you were at a disabling your condition was at a disabling level 9 years ago, getting medical records and getting doctor statements, a real uphill battle. So, ideally, if I see a date last insured that's a year old, maybe 2 years old, not too worried about it. More than a couple of years, there's going to have to be something pretty compelling. That's my experience, my take.
Much harder.
All right. So Jen also, this is the person with PTSD and eating disorder. My judge had to admit I can't do my past work or need breaks, which realistically excessive, but ran around bending over backwards or not. Yeah. So again, what the judge probably did here was say you can't go to past work, but there are other jobs you could do. And if your past work was, involved multitasking, it involved, some sort of, something where you had highly skilled, the judge might say, well, you couldn't do that, or maybe there was lifting that you couldn't do anymore, but they can always find other work. And so that's what, if they want to deny you, that's what they're going to do. They're going to find other work you could do. Laurie says, do you offer services in other states? Yes, I think we both do offer services in all over the country because hearings are done by phone or video. So it doesn't matter. I mean, Stephanie's in Pennsylvania, I'm in Georgia, but I have a hearing tomorrow in, I don't even know where it is. I think I have a hearing in, the judge is in Minnesota, my client's in South Dakota. So it doesn't really matter. Sometimes they'll have a judge, they'll bring a judge in from one state to another state because there's room. So it doesn't really matter anymore. You can ask for a live hearing, but it's pretty rare. Have you done any live hearings since COVID?
Nope.
Yep. Okay. I've done like 2. That's about it. And you know what, I have to tell you, I used to do live, we used to all do just live hearings before COVID. All the hearings were live, except in sometimes it would be a video hearing, but the judge would be by video. My client and I would be in a hearing office. And there was a certain, especially when everybody was in the same room, there's a certain energy you have when you have a judge in the room with the claimant and you and the vocational witness. And I can see the value of that in certain circumstances, but the reality is that after COVID, everything went to phone. I think if anything, it's easier now because I think judges are not, they're comfortable typically in their house or in a room. They're not being exposed to people that are hacking and coughing all over them. The claimants don't have to worry about trying to find a place to park or get into a hearing office. For me, as an attorney, when I went to downtown Atlanta, it's from my office taking the train, I had to leave, an hour and a half early. To make sure I got there on time. And then, coming back, the hearing would be an hour. And I'm coming back. It was, 3 to 3.5, 4 hours out of my day for one hearing. If the hearing was, in a suburban area, I would have to drive there. It might be a little bit less, but still 2 or 3 hours. Now, I'm doing hearings, I could do 2 or 3 a day. If I have them, and one might be in New York, one may be in California, one may be in Wyoming, for that matter. And it's just a lot easier for everybody. That my clients are happier because they're at home, it's comfortable. and the judges like it, and I think it's great. I think the remote hearings are really a wonderful thing. I don't know if you agree, but I think they're
I too.
yeah
For personal, comfort reasons, as well as I think the judges and the clients, of course. I mean, it's really difficult for a lot of people. I mean, we used to sometimes have to travel an hour and a half and have
Yeah.
people to get to their hearing. They have to get a ride if they're not driving or they can't drive that long. Then I always got there an hour and a half early because I like to just gel. In case I broke down and had a little AAA. And my clients would get there an hour before the hearing. I don't know about your hearing office, but we could reserve a room. Like, I got there early enough where I could grab one for other lawyers, and then we would just monopolize it and touch base on some last minute things maybe that someone thought of after our hearing prep on the phone in the days prior. But that's a long day. It was like we were talking about this tonight at the Zoom, or the monthly Zoom.
Yep.
And it would be like almost a whole day event if you have a hearing. You're driving all the way there, you're waiting, sometimes they're delayed, you're waiting in the waiting room, and then by the time you get back, the day is gone.
Yep.
And they're exhausted.
Yeah, it's an exhausting process, and it can really be a pain. And I've even had situations where somebody would come in, and downtown Atlanta, you're talking about $15 to $20 to park, and they go there, and then the judge would be sick, and we'd have to come back. I mean, it was just not real effective use of the time, and it just wasn't really a lot of fun. So the remote hearings are much better. I mean, I can do my pre-hearings by phone. We can just really kind of replicate what's going to be. So that's the way it is now. Again, unless you really want an in-person hearing, but I think they're great. Okay, third round, perp calm butterfly. I have a hearing coming up. I diagnosed chronic pain, depression, and anxiety. Why do they not say I'm allergic to all NSAIDs, Tylenol, Motrin, etc.? Well, I mean, is it in your record? I mean, you can say you're allergic to them, but it really helps if it would be in your record. And I think what you're getting at is that, you've got chronic pain, but you really can't take any medications to relieve it. And that's where you get into a doctor, saying that you're allergic to these medications. There's really no medications that would help relieve the pain. And the pain is such a level that you would simply not be functional at a job because the pain would so interfere with attention, concentration, pace of work, persistence, emotional stability, all those type of things. But, you can't just go into a hearing and say, hey, judge, I'm allergic to NSAIDs. I'm in terrible pain. I can't work. You got to have medical proof. And I realized, a lot of people say, well, and let me just address this briefly. People say, I've paid into the system for 25 or 30 years. Why are they making it so hard to get my money out? Because they don't see it as your money. That's part of it. They see it as their money. And so, they make you prove that you can't do it and you can't work. And that means you got to have medical support. And, you got to get a doctor who's willing to go on record. And that can be difficult because some doctors don't want to get involved in it. And some doctors don't want to make comments about your functional capacity. And some doctors are going to say, well, I don't know what you feel. I'm only going by what you tell me. So yeah, it can be hard. I would just say this: if you have chronic pain, the question I would ask would be, what is the cause of the pain? Is it a herniated disc, or is it fibromyalgia? Big difference. Herniated disc is, you can image that. You can say, well, this person's got a herniated disc with your nerve root impingement. Therefore, the pain is consistent. It makes sense. Fibromyalgia is much more what you report. So, chronic pain and there's got to be a cause to it. So I think this is really going to come down to what the medical record says. Doesn't mean your testimony doesn't help, but I think you got to have more than just your testimony. All right, and this is a kind of a similar question. This got denied for the second time by a judge, had to start over again, had CRPS in all limbs, chronic pain, depression, anxiety disorders. What do I need to do different? Chrissy, this is a problem in that if you reapply, you filed an application, you go in front of the judge, you get denied, you reapply, go back to the same judge, it's going to keep happening unless something changes. You've got to have a different diagnosis. You're going to have different kind of treatment. You're going to have a different opinion by a judge. Maybe your age changes. You go from 49 to 50, and the grids come to play. You go from 54 to 55. The better set of grids apply. So, you got to have something different. Steph, what do you think?
Yeah, I agree. And I would also suggest Chrissy's had 2 denials by 1 or more judges.
Right.
Those judges put in that denial what they found your MDIs, medically determinable impairments, to be, and what isn't mentioned as one, and then which ones are severe. Did they say you have CRPS in all limbs, or did they not? I would find out. And then that might be, maybe your medical evidence isn't properly diagnosed as CRPS. In all limbs, I think is unusual. So you want to find out. I think you always want, if you had a denial with an ALJ, you had a lot of stuff to use to determine what they thought you were lacking. And I would focus on those things in my next photo.
Yep. Yep. But I think it's always hard. It's always very difficult to go back in and, you go back the second time, third time, fourth time, something really significant is going to change, because the judge is going to look at the prior decision, and, even if it's a different judge, they're going to look at the prior decision and say, what's going on here. So,
and has anything changed, exactly like you said, because they kind of give the old judge the respect.
Yep.
Of his finding, the rest judicata or murder.
Yep.
Even for the current time, nothing has changed with the same evidence.
Yep, I agree. All right, Dee Dee says 58 have Parkinson's, depression, spinal stenosis. Yeah, I mean, again, the 58 with Parkinson's, depression, that's right there. I think you've got a pretty strong case. I would be surprised if they would turn you down. I just think that's, I don't remember the first part of your question, but I think that's Parkinson's is one of these conditions that I find judges just recognize it doesn't get better, and they tend to give you more of the benefit of the doubt. At 58, there's probably not going to be a whole lot that you can do. Stenosis, yeah, that's without looking at the record, I mean, just on its face, it looks pretty good. All right, Russell says you need to put in AirPods and turn off all the speakers. Maybe you're getting feedback from the speaker. Maybe that's what that's what Russell's suggesting. I don't know.
We'll have to do this.
Anyway, yeah, we'll try. Yeah, we'll try it another time. Okay. What happens if the ALJ denies you at the hearing? The appeals council does not send it back. You have to appeal to the district court. You got to go to the next level up. And I think that the appeals council many times is kind of a rubber stamp. And I tend to get more, reversals or remands from the district court than from the appeals council. So that's just, that's the way it is, I think. Okay, let's see here. Now I lost my place here. Okay. Let's see here. I apologize, because when I clicked on something and I'm getting I can't find where I was here. Let's try it over here. Well, I'm just going to go. Okay, so this is okay. So anyway, Rodney, and again, Rodney was one of our clients. The administrative judge in his case denies request for virtual hearing and demanded an in-person hearing. The judge you had, Rodney, we got an approval. Someone in the office, Susan in my office got an approval. It's rare that this judge approves anybody, so I'm thankful he got an approval. Of course, he denied the fee agreement. So, Susan, the other attorney, had to file a fee petition, which we have not gotten paid on, by the way. I know you emailed me about that. And so this guy is going out of his way to be a pain in the rear end. Even though he approved you, he didn't want to pay the attorney. But he's the kind of judge who would say, well, you didn't ask for a virtual hearing early, we're going to make you show up. In this case, it didn't matter because it's not that far away. But yeah, this particular judge is not my favorite.
Not make everything harder, right?
Yeah, he just looks for ways to make everything more difficult. Okay. Here. Okay. Let's just go on to this. Okay. Since cybersecurity is a sedentary job, could a disabled person over 50, that job be considered a high SVP? A cybersecurity job, well, again, it depends on how, let's assume it's a sedentary job. That is going to be probably SVP, not SPV, SVP, not SPV. But basically, that is going to be considered a fairly skilled job, I suspect. I haven't looked up the DOT code, but I suspect it is a highly skilled job. So, unless you have transferable skills to let you work a kind of job like that, it's probably not going to be something they would consider. Normally, when a judge is looking at, another job, it's going to be a simple, unskilled job. That's the easy way for them to deny a case. They're going to say you could do an unskilled job. They're not going to deny a case. I mean, they can say you could return past work, but normally what we're trying to prove is you can't do an unskilled job. So, I think they're not going to deny you because you can do, sort of saying, cybersecurity job, let's assume you can't do that. That's fine. You got to be able to show you can't do other stuff too. But that would be considered a high, yes, probably a skilled job, SVP 7, 8, 9, something like that. All right. The AP, do you know what he means by AP?
When the district court sends the remand, does he mean, AP?
I don't know what an
Appeals
AP
counsel? Do you think he means appeals counsel?
appeal. Maybe. Well, district court says remand to the AP. Maybe it means the appeals council. No, I mean, generally speaking, if the district court so let's say you go to a hearing, you get a denial, and then you file an appeal to the appeals council, and the appeals council, affirms the denial. You appeal it again to the district court. The district court remands the case. It remands it back to the appeals council, which then remands it back to the judge, I believe is how it works. So the appeals council is not going to really do anything at that point. The judge is going to get the decision from the district court and based the new opinion, the new hearing based on the instructions from the district court. So the appeals council is kind of out of the picture there. Okay, let's see here. We're still getting some echoing here and there. Okay. All right. Cybersecurity. Let's go back here. Garrett, like my Godfather reference there. Okay. Ty says, I fell under medical listing 1.00 musculoskeletal. Medical expert says I don't meet an expert and got denied. I will tell you from my experience, and Stephanie, you may have a similar experience, really hard to win at the listing level when it's musculoskeletal. That is the hardest one to meet because so many people apply based on back pain. They've made the back pain listing one really, really difficult. In fact, about 3 or 4 years ago, they updated it to make it even more difficult. So it's pretty hard to meet that. I find that, I win a lot of cases. I have a lot of cases on musculoskeletal impairments, but usually I'm winning on the grid rules or I'm winning on functional capacity. So, you didn't win on the medical expert at the hearing says you don't meet the listing. That just says you don't meet a listing. There's 2 other theories you can go under. But yeah, it's not unusual to not meet a listing, in a hearing or any place else. In fact, most cases, if they're going to be approved in the listings, can be done at initial or recon because the adjudicators are looking for that level of severity. It's pretty rare, in my experience, to go to a hearing and have a listing decision based on the listing. So, I mean, has that been your experience as well?
Yeah, for sure. And I think everyone needs to approach their case to win under RFC, the residual functional capacity, because you don't have to do anything about the listing. That's going to be in your medical records organically if you can win that way. You need to work on Plan B, which is the one that is the one most people win under, is the RFC, not a listing.
Yeah. And when she's talking about RFC, that stands for residual functional capacity. And essentially that means that if we look at all of your medical issues, you've got, major back problems, you've got some depression, you've got some diabetes, you've got some chronic kidney disease, you've got, a bunion in your foot, you've got, any number of things going on. It's like a kitchen sink argument. You put it all together and say, let's factor all these things, medication, side effects. When you put them all together, are you able to function in a work environment? And so, that is the RFC, or functional capacity. I call it the functional capacity argument. So there are three, to summarize, there are three ways to win a case. You can meet a listing, which generally speaking is going to be early on. If you apply and you win early, it's going to be because you met a listing. It's rare that you meet a listing in a hearing, but it can happen, but pretty rare. The grid rules are a really strong way if you're over 50, and especially over 55. That's a second theory of disability, where basically you're saying and what the grid rules do is they change the definition of disability. So instead of saying you can't do any work at all, they're saying even if you could do sit down work, even if you could do light work, you're still disabled, because Social Security realizes that a 55-year-old with a bad back, and a construction labor background, there's not any jobs out there for that person. So it's really a reflection of the realities of the workforce out there. So the grid rules change the definition of disability. That's a second theory. And the third theory is RFC, or functional capacity, where you're basically saying that the combined effect of all my problems leaves me without the ability to be reliable at a job. So so what Stephanie's point is that when you file for Social Security disability, look at the listings. Absolutely, look at the listings and make a listing argument. You can certainly, I do it in my applications. I'll say, please evaluate this under listing 1.15. Then I may say, in the alternative, please look at this under grid rule 202.06. In the alternative, please look at the functional capacity, the combined effect of all these things. In the law, you can do what they call argument in the alternative. What that means is that you can basically say, try this, this argument. If it doesn't work, try this one. If that doesn't work, try that one. It's the old joke. Somebody said, gets sued and they said, your dog bit me. No, my dog did not bite you. Secondly, my dog does not bite. Third, I don't own a dog. I mean, you can argue all three. So you can basically say, even if we assume that the person has capacity, they're still disabled. So you don't have to be limited to one argument. And again, I don't think that's what Ty was getting at, but you basically said that you didn't meet a listing. That's not the only thing the judge looked at. The judge is looking at the other theories of disability as well. And the medical expert is simply saying you don't meet a listing, although some medical experts will also talk about functional capacity. So if you got denied, what I would do is have somebody look at it for a possible appeals counsel review, and see whether there's something in that decision that the judge made an error of analysis, so that you can possibly get another bite at the apple. Let's see here. All right, Stacy says hello to you. Oh, you said hello back already. Uncle Ed. Good question, Uncle Ed. Not to be confused with Mr. Ed, who's a talking horse. But anyway, Uncle Ed says, is it possible to be approved by the ALJ without a hearing or before a hearing? Yes, it is. That's called an on-the-record decision. Used to be a little more common. I'm finding that, and I do pre-hearing briefs in most of my cases, almost all of them. And, for whatever reason, maybe they're just really busy, but I don't get as many on the records as I used to. I just think the judges are busy. I don't know. I assume you do the same thing. You're doing briefs, but are you getting many on the records?
No, they're very rare.
Okay.
I do briefs for everybody, all my cases, but
Yep.
I just hope they help at hearing and after.
Yeah.
They help us.
Okay. All right, and Garrett's can always put this in there, which I've got on there. Okay, why does Social Security penalize you if you have a degree versus only a high school education? 62 years. I don't think it's a matter of penalizing you. I mean, their attitude is that having a degree, a college degree, makes you more marketable, gives you more options in terms of jobs. So, that's just the reality of it. I mean, I think if you have a college degree, theoretically, there are more things you can do. Maybe it reflects it doesn't always mean this, of course, but you've got more capacity to do different kinds of work. So, that's why they look at it. I will tell you this, and doing this for 30 years, I don't generally find that I don't see too many denials based on the fact the person has a college degree. maybe it's just because college degrees are kind of ubiquitous now, but the grid rules, if you look at the grid rules, they talk about high school education or more. They don't really talk about college degree. So it's really the lines are drawn between less than a high school education and a high school education or more. So I don't think it's as big of a deal as some people make it. What do you think? Do you think there's?
I don't think it is either. And I think there's narrative on if your education is not recent.
Yeah.
It doesn't very recent. It was more recent than I would have expected. And this is a few years ago. If it wasn't in the last couple, 3-4 years, it was not considered something that could allow you to re-enter right into a spot based on the degree.
Yep.
So that puts people with degrees from 10, 20 years ago in the same boat as a high school grad, really.
Yeah. Well, look, I think that, that's a good point. I mean, if you have let's say you went to college 20 years ago and you got a degree in, pick a topic, in mechanical engineering. I mean, what you learned 20 years ago is outdated right now. I mean, I went to college, many, many years ago, and, I obviously, I was a history major, and, the history that we studied stopped at a certain point, and of course there's been a lot more history since then. I wouldn't be qualified at this point necessarily to go in as a history teacher. When I got out of school, I might have been. So I think that Steph's right, is that the amount of time it's been since you got out of school, what you studied, may be completely irrelevant to a workforce right now. So I don't think they punish you. I think it's just maybe they benefit you if you have if you have an 8th grade education. But I don't think it's really they punish you that much.
Yeah, it's got to be super low for it to even be a speck in the eye for them. Like 7th grade, I never got past 7th grade.
Yep. All right, Tat. She can hear me. I'm glad I talked to Tat today. So hello, Tat. Let's see here. Gator. Mr. G, had my hearing vocational expert said there was one job. The judge asked about my limits and said no jobs. What are the chances you win your case? Again, if you end up with a judge saying there's no jobs, that's a good thing. And the vocational witness saying there's no jobs, that's a good thing. Realize that judges ask multiple hypothetical questions many times. They could ask 3 or 4 or 5 or more hypothetical questions, and one of those questions reflects what the judge is thinking. We don't know which one it is. So, it is possible that the judge asks a question and the answer is you could be a, ticket taker to a movie theater, or whatever the case may be. You could be a laundry marker. Let's take an example. And then the judge asks 4 more questions and the answer is no jobs. And you get a denial because you could be a laundry marker. So you don't know. But generally speaking, the more times the vocational witness says no jobs, the better. So I think that, from what I'm hearing, what you're doing, if in fact the judge asks a hypothetical question, and the VE said one job, okay, that right there says that may not be enough to constitute a real, what's the term I'm looking for? That
significant numbers in the economy.
That's right, significant number of jobs. One job probably wouldn't do it. And then if the judge added something to that got no jobs, based on that information alone, I think that's a pretty good sign. Tanya. Okay. You're not a bad client, Tanya. You're not good. A lot of people aren't good with computers. Use a phone for your computer.
Like me.
I'm not. I didn't say that. I didn't say that. Yeah. I didn't, I wonder if Tanya could make her audio work. I don't know. Okay. But Tanya's been in a salon for years, not in an office, and probably bending over, doing hair. So yeah, I mean, there are jobs that, many jobs require certain use of the computer. And if you don't have that computer skill, that's something I would bring out in testimony, that you don't have computer skills, because that is very relevant, because a lot of jobs out there do require some computer skills. So yeah, I think that actually helps your cause, even if you have, let's say, a college degree. If you're not computer savvy, then you're essentially going to be limited to the type of jobs you could do. Let's see. Okay, Tat says, I had a gentleman as a guest that mentioned an MDQF, and I didn't find the show notes for that live. Where can I find the mental questionnaire for the psychiatrist to fill out? there are a number of places, and let me, I think I've showed you that in previous live streams. Let me go ahead and show you a couple places. There is one where if you go to, I'm gonna do, I'm just gonna put it in the comments. So you can see a couple places where you can get some free functional capacity forms. That's one. And then I'm gonna give you another one here. There's a couple websites that have them, and I just put them in the comments, and that would hopefully help a little bit. And that was a couple weeks ago. I had God bless, I'm drawing
Yoda.
the Yoda on. Okay, I had the disability Yoda on. Okay. Okay. Cinematic Rich. I was denied SSDI even if I had proof. Died, revived in a crash, had 2 surgeries, a lot of therapy without word. Walker's denied. Again, it's hard to really say what the evidence showed. And by the way, the Yoda is Greg. Why am I drawing a blank on Greg's name? I'll think of it in a second.
Everybody knows the name Yoda, though.
Yeah, the disability Yoda. Yeah, okay. But anyway, that's embarrassing. I'm drawing a blank on it totally. But anyway, denied SSD even if I had a proof that you revived in a crash. Again, what are the limitations you've got? That's really the question. That's the really question. I mean, all these things that happen to you, I think are relevant, but what is that? How is your functioning? How has it left your functioning? What do you think? Would you agree?
Yeah, I mean, it does say he had 2 surgeries a year's worth apart. I'm assuming he had one, and it maybe didn't work out so well, and he had another. It depends what the surgery was. Was it to get you walking? And then he was on a walker. How long? Did he meet the 12-month duration of no work at all? Couldn't even do a sedentary unskilled. Was he denied at ALJ or just on initial? I wonder.
I don't know.
Because if it was just on initial or recon, don't give up.
Yeah, that's true.
Yeah.
Right. So if you're denied an initial, that's exactly right. Go ahead and file reconsideration. Because again, if you had severe car crash, 2 surgeries, lots of therapy without work, discharged with a walker, that you may not meet a listing, but you very well may, be approved at recon or at a hearing. Greg Brinkley, by the way, is the person I don't know. So Greg, if you're watching, I apologize. I don't know, for some reason I drew a blank on your last name, but Greg Brinkley. I should just think of Huntley Brinkley from back in the day that did the news. And most people are not going to have any idea what I'm talking about there. But anyway, okay. But yeah, I think I'm assuming you said you got denied a hearing. It wasn't a hearing. If you got denied an initial, go ahead and appeal. Absolutely. I think that would be worthwhile. But yeah, I think you want to focus on those things that are, functional in nature. He said he had 4 broken bones and a brain bleed. Yeah, I mean, all these things.
That was connected to it.
Yeah. Okay. What is your experience with the client getting diagnosed with dementia? I cannot remember Greg Brinkley's name. Maybe that's me. I don't know. Or beginning Alzheimer's. How bad? How far can it be? Workers already knows complaint. Okay. So, I mean, I think that, a diagnosis of dementia or beginning or early Alzheimer's, that's obviously something that generally does not get any better. So I think that, if you stop work and you're symptomatic to the point where you're having difficulty remembering things, you can't process things, you're making silly mistakes, and things that you know how to do, you stop working, I think that, you're going to get the benefit of the doubt. Does that mean you get approved early at initial? No, it doesn't mean that at all. But I think it probably does mean, just like with Parkinson's, there's certain conditions that in my experience, judges just realize are not going to get any better. And if it gets to a certain point, you might even go to the compassionate allowance list where you could win there. But I think that dementia, early Alzheimer's is one of those conditions that, usually you're going to get more of the benefit of the doubt than not. Agree? Steph, would you agree?
Yeah, I think it's a big one.
Yep. All right. Jen, ME is very cynical and basically so he's alive, so he can work. I don't think it's quite that bad, but yeah, I mean, if you're asking me, do adjudicators turn down cases that should be approved? Absolutely. Every case that we try has been turned down twice by adjudicators. So, every single case that is going to a hearing has already, like I said, been turned down twice. So yeah, making a mistake. I think that adjudicators at the state agency, and I'm going to try to get one on here to maybe get from the horse's mouth, but they have limited authority. I mean, they're looking for very specific things. They're not seeing you, they're not hearing from you. They're going to be really looking mostly at listing level or grid rule cases. They can approve based on a functional capacity, but getting all that evidence to them, it's hard because it's judgment calls. Credibility, even though credibility is not supposed to be a factor, it really is. It's hard. So I don't blame the adjudicators. They have a lot of time. They're under a lot of pressure, but they're gonna lean towards finding somebody not disabled as opposed to somebody being disabled. If there's questions, some sort of ambiguity in the record, and you get to a judge, you have a little more of a broad-based kind of look at things, I think. Okay. Okay. So yeah, Cinematic Rich says, what is the judge going to say when he sees a list of injuries? Again, I don't want to beat a dead horse here. It's not about the list of injuries. You may have, 15 diagnoses, 15 injuries, but the question is, how does it affect you? How does it affect you? That's really what you want to talk about in a work environment. Lillian says, thank you for a great informational program. You are very welcome. I'm glad we are able to help. Let's see. Okay, and Jen says, I think Jen and Cinematic Rich are having a personal conversation here, but most more things change. What her point is that, certain places have very low approval rates. You get a judge and it keeps going back to the same judge who's got a low approval rate, maybe you have to move. Yeah, that's correct. Sometimes it does make sense to move. I mean, I find, for example, that cases in Texas are much more difficult to win.
Are you frozen, Jonathan?
I am not. No, I'm not frozen. You seeing me frozen?
I thought for a split second it looked like you were frozen for me.
Okay. Okay. Well, I'm. If you saw me in the tennis court, you might think I'm frozen because I don't move really well. So that's the.
At least you're out of the tennis court.
Yeah. No, that's the criticism. I played today before it started raining, and somebody was making a comment like, "Do you move at all?" Like, yes, I move when I have to move. It's 'cause
I swing my arm.
Yes, that's right. I'm standing there. I'm trying to be intimidating. But yeah, sometimes you have to move, or you're not going to get a real shot at it until you do move if you're in a very low approval district. Okay. Let's see. Okay. All right. So Cinematic Rich, again, a lot of things going on. Yeah, I think these are, if you've not, and he's got abnormal thyroid. So all these problems here are logically going to generate some medical issues or some vocational issues. So again, if you have been denied an initial, appeal it. Absolutely appeal it. Do they consider living in a tent homeless? Yeah, I would think so.
Unless it's in your own backyard.
Yes. Okay.
If you own a house in a backyard, but you live in your tent.
Yeah. And we don't mean to be facetious about it. There are a lot of people that I've represented that live in their cars, that are living the couch surfing. I mean, 2 years is a hell of a long time to wait with no money coming in, and really, people can suffer. And that's why, I'm a little quicker on the draw to tell people to contact their congressperson. Like, look, I'm struggling here and I need a decision. I talked to somebody the other day, one of my clients or a potential client, and they've been waiting 10 months and there's nobody assigned yet. I'm like, yeah, get on the phone, call your representative and say, it's been 10 months. I'm running out of money. I want to.
And prior to that, if you're couch surfing, you're homeless, in my opinion.
Yep.
And you should be able to request a expedition based on the dire circumstances of homelessness.
Dire need, yeah, but it's hard. That they don't.
I know, it's still slow. It's crazy.
It's still slow, yeah. All right, Chow Show says, disabled adult child getting a big check. Hey, good for you. Disabled adult child cases are hard, especially if you're trying to, and what that basically means is that you have to prove that you became disabled, I think, prior to age 21. So let's say that you're age 35 now. Well, you got to prove you became disabled, 14, 15 years ago. That is hard. That is really hard, because getting evidence going back that far can be a real struggle. So I applaud anybody who wins a disabled adult child case when they're going back, 10 years or 10 years plus.
Right.
Okay. All right. What are your thoughts in cases remanded from the district court and the original ALJ has moved to a new office? That's a good thing, because if the ALJ denied you, you want another judge to look at it. So I think it's a good thing. I should say always, assuming that the new ALJ has a better than approval rate than the old ALJ, usually I would much rather have a new ALJ than the old one. But you don't always get that choice. In fact, somebody was
Usually
telling me,
you don't.
yeah, somebody was telling me that's not really even policy. That's just that's not law. It's just policy. They just send it back to the same ALJ, which makes very little sense to me. But now I will tell you that some ALJs, judges, are a little intimidated when they get a district court remand, and they're going to be more likely to approve you. Maybe yes, maybe no. I don't know. But I think if it was up to me and I could choose, I would say get different ALJ. Okay, well, okay. I hear what you're saying, Rich. I know it's frustrating.
Yeah.
I know it's frustrating. Okay. All right, Gator, who I assume is a Gator fan based on the icon there. Had my hearing. The vocational expert, some jobs, and the judge asked about limitations, no jobs. Again, it depends on which question the judge chooses. That's really what it boils down to. You don't know which hypothetical the judge is going to use. And we've got 15 minutes left, so we're going to kind of zoom through some of these. The ALJ is listening to your hearing notes. Google the judge. Yeah, that's right. Google the judge. Look, there's a couple of places you can go. ALJ approval rate, for Social Security, and you'll come up with 3 or 4 different places, and you can see. But you know what? Don't assume that because your judge has a 35% approval rate that you're going to lose. I think that you have to go in with the idea you're going to present the best possible case. I've won cases with judges that have 15% approval rates. You don't know. And I think that you want to go in with as much credibility, practice as much as you can, and be able to explain very clearly why you would not be able to work. Again, if you have an attorney, which I think you should at a hearing, practice with your attorney so that you know when you go in that you lay everything on the table. Okay. How long will ALJ get back to you for dessert? LaQuisha, I do not understand what you're asking there. I'm sorry. Ellie Brown says the ALJ decision is scrutinized by another judge favorable. Okay, what she's getting at, and she's right, is that after the judge's decisions are issued, there will be a quality review at the appeals council level, I think, but somebody's looking at the judge's decision usually. And I don't know, this is a good question. I don't know if every decision is being looked at or just some of them, randomly, but there's a certain percentage at least of decisions that are looked at. And I think twice in the past 30 years, I've had a decision that was issued, and then before it was released, it was taken back, and the appeals council asked for another hearing. So it can happen, but it's pretty rare. I don't know if you ever had that happen to you.
I did have a hearing once where there was one hypothetical, a younger individual, and the hypothetical the judge gave to the VE was no jobs.
Yep.
Hearing was over. It was beautiful, but I was very, very concerned, even though it was a beautiful outcome.
Yeah.
And lo and behold, a couple months later, we got a call saying, "Oh, we're scheduling for a hearing on so-and-so." And I said, "No, we had a hearing, and it was beautiful."
Yeah.
We're not having a. And she's like, "Oh no, all the hearings are getting redone." And I think it was a judge, possibly, who was. This is only a couple years ago.
Yeah.
Who maybe in their mind was going rogue with awards. And we did have another hearing. This was a very, very long case as a result. I knew that we got a new hearing, and that judge, who has since passed away, did a very quick denial. We appealed it to the appeals council, won that appeal, went back to hearing, and then won.
Mm-hmm.
And she was a younger individual. it was the kind of case where maybe you wouldn't have taken it, but you
Yeah.
just felt like you had to. And it worked out in the end. It took like 5 years, but
Yeah. Yeah.
she got the whole kit. So
That's 5 years of waiting with no money for the client, which is not
yeah.
good.
I mean, you got it eventually without interest, of course.
Yeah, of course. All right.
Yeah.
How long does it? I think LaQuisha. How long do you get an answer from this? So if you have a hearing, it can be 2 weeks. It could be 6 months. It could be 8 months. I mean, I think on average, it's probably about 2.5 months, 3 months is my average. Would you say?
I agree.
It just
All
depends.
that.
Yeah. Okay. What is the final review process for appeal after a hearing? You have to file an appeal to the appeals council within 60 days of the date you received the denial notice, which is assumed to be 5 days after the date on the denial notice. So 65 days after the date on the denial notice, you've got to get an appeal filed to the appeals council, which you can do online. And really, I think you should have an attorney do it. There are attorneys who specialize in appeals council work. I refer out to them, and not all the time, but most of the time, because it's just a separate practice area. Do you do your own appeals?
I do.
Okay.
I do.
Okay.
I don't do FTC.
You don't do what?
I don't do federal.
Yeah.
District.
Yeah. Okay. Will my wife with 59 when I complete my 24 months also qualify for Medicare? I don't think so. I don't believe that your wife, if you qualify for disability, you become eligible for Medicare before 60, before retirement age. I don't believe that your wife would become eligible for Medicare based on your disability. If she's not disabled herself, what happens to her TRICARE coverage? I don't know. Honestly, just don't know. That would be a question to pose to folks at TRICARE. I do not know. I'm sorry, Jose. If someone says meets a couple of grids, is there a good chance of getting SSI? Okay, if you meet a grid, that's a good thing. Does SSI slow down payment? Yes, because they've got to do the income and resource interview, and they've got to determine whether you still qualify for SSI. So it does slow it down a little bit. After the hearing, it says some of my case final review. It just means there's quality control. They're looking at it to make sure that all the T's are crossed and I's are dotted. All right, Britt, I have no feeling in my lower legs and feet. Also foot drop and Claudia Aquina. Do you think I'll get approved? Again, you don't say how old you are, but I mean, those are pretty significant problems that I think would be significant work problems. So, I would say based on that, probably, theoretically you could do a sit down job. Although, Social Security does not factor in how you might get to work or how you get from the parking lot to the job. They're looking at when you get to the job, could you perform it? So theoretically, you could do a sedentary job without feeling in your lower legs and feet. But I think if you're over 50, I think you meet a grid probably. And I think otherwise that's pretty serious. I would be surprised if you got denied, but nothing surprises me these days. Okay. Let's see. Garrett, you have a shout out. All right. Luke says, I got enough credits for SSDI. Past 10 years, we're the same company. We'll go back and forth between 30 hours a week as well as 5 or 10 hours a week. Okay. So if you've got enough work credits, that's a good thing. So now you're qualified for SSDI. Now you have to prove you've got chronic pain starting 20 years ago. But work history should be fine. And again, if you're not sure, go to ssa.gov/myaccount. You can download My Social Security statement. So, you can see if you're insured, but then you have to prove that you're disabled. All right, Jen says, it's not that simple. If you need excessive breaks, you're considered disabled. Those are the rules. Judge makes things up. That's when remanded. Yeah, I mean, again, if the medical evidence shows one thing and the judge stated something different, this is a reason, grounds for appeal. If in the hearing decision there is information that the judge relies upon and says, that the claimant testified that, she did not need more than one break a day for 5 minutes, but the evidence shows otherwise, that can be grounds for appeal. Absolutely. So, judges realize the judges don't write their decisions. They send it to a decision writer in a different state. and that person writes it up based on the notes. And there are sometimes things that get lost in translation. And yes, you can have a situation where the facts or medical evidence is quoted and it's just flat out wrong. And that would be grounds for appeal. The judge relied on evidence that was wrongly identified, wrongly quoted. So absolutely. Freedom 64. Just want to say for those starting this journey, it took me over 3 years. The judge approved me on the phone in a grid rule. Yeah, I think that's not uncommon. Not uncommon. Okay. Okay. Oh, great. Okay. So Redding, Anna Maria, this attorney, that would be me, said, help me get approved by videos, knowledgeable, experienced, and honest, having a functional evaluation, and Walker assisted me getting approved. Thank you very much, Anna Maria. I hope glad the videos are helpful. And that's why I put them out there, to hopefully give people some, give some information, share what I know. That's why we're doing this, sharing what we know. Let's see. Kathy, daughter's 36, last worked 2021, finally got diagnosed after years of symptoms. I don't know what HEDS is, POTS, which is a problem when you stand up and your blood doesn't flow, epilepsy, heart. Told by two firms wouldn't take her case. Doing the 5-year rule is just right. I don't know why the 5-year rule would prevent somebody from taking that case. It probably is because she's 36. It's really hard to win when you're in your 30s. And, you know, Ehlers-Danlos, that's what I use, EDS, Ehlers-Danlos. So Ehlers-Danlos and POTS cases, epilepsy, you know, they're hard cases. I've won some Ehlers-Danlos and POTS cases for younger people, but it's really hard because you got to have really, really strong evidence. And so my guess would be that they turned you down, not because of, you know, anything that you did wrong. It's just that you're young and the odds of winning are just not, you know, not as great at 36. And, you know, attorneys like us, we only get paid if we win. So you have to be selective. And unfortunately, it makes it hard. And, you know, the Social Security doesn't incentivize people. You know, we don't get incentivized to take more difficult cases. And so, you know, we get paid the same whether we take a hard case or a person over 55. So, you know, it's just the reality of it. We got to run businesses. And so, unfortunately, that's why people in their 30s have such a hard time getting attorneys. Steph, I didn't ask you before. What is your video channel called? Is it All Things?
Yep.
Okay.
All Things Social Security.
Okay, so you check Steph out on Stephanie Joy on YouTube, All Things Disability.
All Things Social Security.
All Things Social Security. Sorry about that. But
yeah, sometimes we touch on retirement.
Yeah. Okay. Okay. Somebody tells me I'm annoying. You're not the first person. I turned on my speakers and wear earpieces. Okay. I didn't. Okay. I'll turn the speakers down. Getting kind of late in the game, but okay. Okay. So, well, we're getting kind of late in the game, so we're just going to finish it out with what we got here.
Yeah.
All right. After 3 years of getting turned down twice at hearings that lasted only 20 minutes, was approved. Puzzling why most of the time it takes to get a hearing. Yeah, you know, you get a couple of appeals and the district court remands, and judges are just going to say, I'm not going to fight them anymore. And I think it probably, you know, I don't know this for a fact, but I'm guessing that judges with a lot of remands, you know, are going to be looked at in terms of their, you know, I don't know whether it's being rehired or their earnings or whatever it may be, but I suspect that judges don't really like it when their cases are repeatedly remanded. Be my guess. Ellie Brown says, got to have a paper trail and continue doctor's appointments. Don't stop. Very good advice.
Yep.
Very good advice there. All right, this is a tough one, and we're getting close to the end, but we'll, Stephanie, why don't you take this? How does a 57-year-old man with Meniere's disease, and you got all the accents on Meniere's. I don't know how you do that because I don't. My keyboard will do that. In both ears, anxiety and concentration. What's your take on Meniere's disease? Have you had much luck with that?
It's generally not the only thing they have. So that would be like limitation on hearing, but then you have all those jobs that don't require.
Isn't it balance also?
Acute? Yeah. Right. I guess it's a combination, right?
Yeah. Oh. I think it's balance too. I think it's like, you know.
Oh yeah, it could. Yeah, you're right. Is it? Yeah. And it's like the ringing in the ears too, right?
Can be. I mean, I always thought it was more that they just feel nauseous and room spinning and
Oh,
kind
yeah,
of
the
dizzy.
vertigo.
Vertigo, that
Yeah.
kind of thing. Right.
My pretend stepfather
Yeah.
has Meniere's, and it would be both, but and a constant, like something going on with his ears. So
Yeah.
I'm seeing part of this, but not all of it. Is it?
Yeah. I think that's all I'm seeing here. But
Okay.
essentially, what he's asking is that
Yeah.
you know, the psychologist, the consultative psychologist, said that there are some concentration issues. He's got Meniere's.
Okay.
What does that all mean? And there's some anxiety as well. Would that be something that is likely to get approved?
It really depends, I think, on his work history. It's skilled or unskilled. It's the whole grid thing and the transferability of skills. And I mean, it can be serious stuff, and the Meniere's can be serious. But do you find that vertigo type of issues
I've
tend to
won
be
some
more
cases.
difficult?
Yeah, they're difficult because again, it's subjective. I mean, there's no way to really measure it. It's the testing that is done, and I guess the people that do vestibular testing are knowledgeable about making sure that people are not exaggerating or malingering, things like that. But it's still based on what you report, so it's difficult in that regard. And it's hard for a judge to know how bad it is. If you have Meniere's and you have some vertigo and dizziness, for a couple hours a day, is that going to disable you from every job? If it's, 5 or 6 hours a day or all the time, it probably would. I would say you probably would need some sort of a strong support from a vestibular specialist, and evidence that treatment, and there's some different treatments that can be done for this, the treatment has not been effective, and that the psychological part that you cannot, focus and concentrate. You put all this together at 57, you got a better shot than if you were 37. But it is a harder way to go. Anything that cannot be imaged, anything that you can't take an MRI or a CT of, that there's no objective testing on, that is by definition going to be more difficult. So I think that you got a shot here. I think it's going to really depend on what the doctors say, how strong the medical records are, and and what your testimony is. Maybe keep a diary of episodes of vertigo, how often it happened, and how it affects you. Maybe have some third-party statements about people talking about when they saw that, when they could tell you were having an episode, and what you did, and how you appeared to be, you had to sit down or you had to lie down or you just
Bedridden.
non-functional. That could help as well. So
and KJ, don't forget, don't leave out. I mean, you're 57 years old. I'm right there with you. If you have any arthritis, any other impairments that you don't think of are a big deal because your Meniere's is so bad, like it's overwhelming to you, as is, say, the concentration and anxiety. Don't forget those other physical things, because they're going to be very critical, particularly in the over 50 crowd. So if you have bad knees, you had a knee surgery years ago, and it's going to prevent you from walking all day long, I would work up that in addition to all this.
Yep. Yeah, and I think just as a final point, I mean, Meniere's disease, because it affects balance, I think that the grid rules could be argued. You could say, you can't do, light work because it's standing and walking 6 out of 8 hours. So, I think that you could make an argument that the grid rules, we wouldn't think it's, because it doesn't seem like it's an exertional problem, but I think it would certainly prevent you from, again, standing and walking, working on unprotected heights, things like that. So, you might even look at that. But yeah, I think that, you have to get creative with the evidence, I think is our point.
And do you report your episodes to your specialist?
Right. If you're reporting your evidence, right, you might want to just make an effort, make sure that every time you have a bad episode, send your doctor an email, keep track of all that stuff. Somebody mentioned this before in the comments, paper trail. I think it was Ellie made a point. Paper trail. The more you have a paper trail of documenting what's going on, the better. Sometimes doctors' notes don't include all that stuff, and you got to get it in there by just sending your doctor an email, sending them a letter. I mean, I've seen medical records with emails in them from the claimant, and the claimant talking about, I've got this problem, I've got this thing going on, and it gets in the record. It really can help you. So you want to be creative when it comes to that. So, all right. So we are now at 10:30 Eastern. Any closing thoughts, Stephanie? Anything that comes to mind as we close?
No, I would just end off on that last thing that for everybody, treat for your big impairments and your small ones. That's going to start nicking away at all those 12,000 jobs. You have to prove you can't do any of them for all intents and purposes.
And Stephanie, tell everybody how they can reach you if they wanted to get a hold of you.
My website is joydisability.com. That's JOY disability.com. I am on YouTube, all things Social Security. It's usually just middle of the day, short things of what's happening and an issue that cropped up during the day that I think can be helpful for people. So they're really short. And yeah, and at the website, there's a phone number there. There's email. So whichever way, folks, or the evaluation form. So
okay. Very good. Very good. Well, I appreciate, thanks for joining me. And again, we'll work on the audio. The audio. But, so I apologize to everybody out there that your audio was not up to par at this point. We're still learning.
We'll
I'm
figure
using
it out.
StreamYard, and again, it's web-based, but we'll try to figure it out and try to get it working a little bit better next time. But I appreciate everybody for tuning in. Send me your questions. Leave me comments. If you want to email me, my email address is ssdanswers123@gmail. If you want to send me a question, or on the YouTube channel, you can message me that way. And again, if you have an opportunity, leave me a review, leave Steph a review. Reviews are always helpful if you got value out of this. And I think I've put my website up there, ssdanswers.com. Let me just put it out there one more time. If you'd like a case evaluation, happy to do that. And again, I really appreciate all the questions, everybody taking the time to join us on this Wednesday evening. I hope it's not too hot where you are, and we will see you all next week. Thanks a lot.
Have a good one, everybody.
Bye-bye.
Bye, Jonathan. I'll talk to you later.